Appeal and for the Fifth District of the State of Florida is now in session. The Honorable J.P. Cohen, Judge presiding. All persons having business before the court, draw near and give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Well, good morning. Welcome to an oral argument session of the Fifth District Court of Appeal. I've been introduced already. Let me introduce the other members of the panel to my right. From Marion County, Judge Brian Lambert. To my left, from Seminole County, we've got Judge Jim Edwards. We've got 4 cases on the docket this morning. The 4th case is going to require a change of panel, so we're going to take a 5-minute recess between case number 3 and case number 4. All cases will be allowed up to 20 minutes each. I have basically a default of 5 minutes for rebuttal. If you'd like something different than that, just let me know, and I'll be glad to accommodate anything that you'd like. If any of you have any audio devices that phones, cell phones, any beepers, anything like that. Do people have beepers anymore? I don't think they do. But if you just make sure that they're on silent, that way they don't interrupt the flow of the argument. So we'll start with the first case on the docket, which seems a logical place to start. Gutierrez versus State. Good morning.
Good morning. And I'll just be requesting 5 minutes for rebuttal if that's fine.
That's terrific. At your convenience.
May it please the court. My name is Fabian Goff on behalf of the appellant in this case, VIVIANA Gutierrez. So the lower court erred in 2 separate ways. First, by denying the appellant a jury instruction on temporary possession for legal disposal. The second way that the lower court erred is by overruling an objection made during closing arguments where the state had referenced appellant's right to remain silent, such error constituting harmful error that contributed adversely to the verdict.
Okay, let's start out with the legal definition of legal disposal.
The legal definition of legal disposal, as laid out in the jury instruction, if someone is throwing away, disposing, or trying to hand the drugs into the police, that constitutes legal disposal. So our contention is that under the definition of throwing away, a prompt return to the original possessor falls under that definition.
Well, why would it fall under that definition?
Well, there are multiple ways to throw a substance away.
If I have this pen and I give you the pen because it was your pen, have I thrown it away?
Well, our contention is yes. So we're likening the term throwing away to ridding oneself of the substance. There's no definition within the jury instruction of what to throw away means. And there seems to be case law that suggests that promptly returning that substance to the original possessor could constitute throwing a substance away.
Case law down here where it's warm or way up there north where it's freezing all the time?
Where it's a little bit colder.
Yeah, and I know some of our cases have cited to the Alaska case, but when they cited to the Alaska case, what was that, Stanton, I think it was? We
Yes.
cited, the Florida court cited to it. They specifically stopped at throw it away, destroy it, or give it to the police. They didn't say give it back to drug dealer, casual drug dealer, whatever it is. They definitely left off that one thing that the Alaska case turned on, didn't they?
Well, if we turn to the case of State v. Ram Subhag, citation Southern 2nd, 937 Southern 2nd, 1192 out of the 4th.
In Stanton, I'm correct, right? Is that the right name for it?
Yes,
Yeah,
you
okay.
are correct. But out of the 4th District Court of Appeal, so in the Ram Subhag case, the defendant there had tried to utilized the defense of temporary possession for legal disposal. But the facts, the undisputed facts, is that the defendant was trying to return Xanax to his boss. So in that case, the 4th District Court of Appeals seemed to have no problem, at least at first, attempting to apply the defense of temporary possession for legal disposal to those facts. Where the 4th had taken issue was with the amount of time with which the defendant had held on to the Xanax.
Well, it's easy not to adopt a test, a new test, when you say, because of this other thing, we're not going to apply it. So it's not like they looked at it and may have thought about applying the test, but it didn't work in that case, right? So they didn't actually apply the test and let the guy off for that reason. They looked at it, they kind of hypothetically played with it and said, yeah, right, you kept it for 10 hours instead of giving it right back to your boss. We're not buying it.
But our contention is if the 4th wanted to say something like a prompt return to the original possessor would not constitute legal disposal, that would have been the perfect time for them to say that. And that is our contention. So,
In prompt.
oh, I apologize.
But there was nothing prompt in the case, and so I don't know why they would say that,
But they also, oh, I didn't mean to cut you off, I apologize.
Go ahead.
Well, they also would have referenced his intent if that was a distinguishing factor, saying, well, returning it to this person, even though they were legally prescribed it, would not have constituted legal disposal. That would have been the perfect time for them to say that. As I pointed out in my reply brief, this was actually before, I believe, the agent defense for possession of a lawfully prescribed substance was created by the 1st District Court of Appeals.
Had the pills been lawfully prescribed to his boss?
From my reading of the case, it seems yes.
Okay, so that is a little different twist here. I don't think her passenger had a prescription for cocaine, did he? I mean, that's, again, if you really oversimplify it, it seems like Florida goes, okay, if you're doing the right thing with those drugs you found, throwing them away, destroying them, or give them to the cops, if you're doing, quote, the right thing, you're not committing a crime, but is giving it back to the drug dealer the right thing? I mean, are you helping to hide the drugs from the officer? I mean, that's certainly a fair reading of the evidence here.
Well, the
And
issue...
she tried to conceal it, didn't she?
Well, that was what one of the state witnesses had said.
But don't we have to look at the facts in the light most favorable to the state at this point?
Well, that is correct, but going back to Judge Edwards and his contention, the issue here is that someone had left the drugs in her car. So she was left in an untenable situation where she picked up the drugs and she was trying to hand it back to him because, as I laid out in my brief, notwithstanding the case law, which we still believe points in our favor, but there are still certain policies as to why that may have been the best situation or solution. Because if she had destroyed the drugs, then she could have been charged with a felony, potentially. If she had tried to dispose of the drugs and the officer had seen her, then she still could have been arrested, and then it was possible that that could have been construed as abandonment.
She could have just given the drugs to the police officer, couldn't she have?
Well, that doesn't necessarily mean that she wouldn't have been subject to criminal prosecution.
But then she'd have a jury instruction about temporary possession, right?
Well, possibly, and then she...
Well, clearly. I mean, because you'd say, you'd be up here saying, if that's what she did, and then the trial counsel asks for the instruction, and the trial judge says no, you'd be waving Stanton at us correctly, saying the minute she had contact with the police officer, she tried to give him the drugs and explain, not mine, passenger, don't really know him, here. Now, the officer may not have believed her and arrested her, but you would have your defense.
Well, and what I meant to say was it would still be up to the jury to believe her and find her credible regarding
She might
that.
be lying, too, yeah.
The jury doesn't believe her.
Well, if the jury doesn't believe her and she's entitled to the instruction...
But she
then-
gets the instruction is the
Right,
point.
that's the point.
But then even a case I wanted to bring to the court's attention, Joshua v. State, citation 205 Southern 3rd 851, a 2016 case out of the 4th District Court of Appeals. The 4th was actually faced with a similar situation to what the court had just hypothesized, where drugs were delivered to their apartment, methamphetamines, and the officers had arrived at this person's home due to a tip. The person actually welcomed the officers inside of the home
Did you cite to that case in your briefs, Joshua v. State?
I did not cite it in my brief, I apologize.
And did you do a notice of supplemental authority?
No, I did not.
Wait, then you can't talk about it.
Can't sandbag.
Well, I apologize. But I did want to bring to the court's attention that there have been situations like the court has contemplated where someone is still arrested, they still go through prosecution, they still have to bond out potentially. And here, this prompt returning is something that could avoid that prosecution.
Well, but the prompt returning is a defense. It doesn't guarantee that you're not going to be arrested and prosecuted. You know, the police tend to be somewhat suspicious of those circumstances, but it's up to a jury to convict, not up to the police to convict, and so it allows a defense. It's not a stand your ground immunity type of situation, right?
Well, correct. It would still be ultimately up to the jury, but this isn't something that courts have explicitly said is not legally viable or completely illegal, because I have cited...
Yeah, why wouldn't anyone in a possession circumstance then, under your theory, if they get on the witness stand and say, these weren't my drugs, I was going to return them to the rightful owner, be entitled to that jury instruction, if they get on the stand and say that? Under your theory, everyone charged with possession would be entitled to that instruction, right?
As soon as the rightful owner came back from his worldwide cruise, and in 3 months, I was going to give it back to him the moment I saw him.
Or if she's going to give, you know, he or she will give it back to him, you know, as soon as possible, but whatever. But they get on the witness stand and they say that. Under your analysis, they would be entitled to this jury instruction, right?
Well, if the court does find that promptly returning it to the original possessor does constitute throwing away, then yes, the trial court would have to make the initial...
Under every possession case, as long as the person gets on the stand and testifies to that.
And testifies that I picked up this substance with no unlawful intent, and I had tried to promptly return it to the person who had given it to me or unlawfully left it in my home or vehicle or whatever.
How do you, I mean, I think I know, your answer, I think, is going to be that she denied this, but the evidence that we have to take in the light most favorable to the state indicated that she knew the nature of the substance, that it was cocaine. In fact, when the arresting officer tested it, I think for heroin, it came back negative. You know, his testimony was that she told him it was cocaine. Wouldn't that be inconsistent with someone simply leaving something on a seat and she's going to destroy it or get rid of it? How would she know what it was?
Well, I believe her knowledge of what the substance was is actually irrelevant toward the defense. If someone had left marijuana...
But you don't think that, well, marijuana is fairly obvious. I don't know that it's going to be mistaken for any other controlled substance, but you know, a white powder could be methamphetamine, it could be heroin, it could be any number of different things, but she knew what it was. And isn't that inconsistent with, hey, someone just left something, what appears to be drugs, and I want to, I'm going to throw it away. How would she have known the nature of the substance?
Well, I respectfully disagree that her prior knowledge of what the substance could be means that she must have some familiarity with that specific substance in her car. She still doesn't, she might know what cocaine looks like and may have had a guess at what it was.
All right, why don't we turn to the second argument that you raised, which was the statement during closing arguments.
Yes, so regarding the second error, which was the trial court overruling the objection made during the state's closing argument, where the state had commented on the appellant's right to remain silent by stating, why didn't she tell the officers that these aren't my drugs? As the court is aware, the question is whether or not the remark or the question posed is fairly susceptible of infringing on the right to remain silent. as laid out in my brief, the right to remain silent also covers the failure to make an exculpatory statement during a detention or arrest.
Did she talk about that during her testimony, though? Wasn't she asked questions of that nature about, why didn't you say something to the officer? And she answered without objection? Isn't that what happened?
Well,
My point being then, okay, so it's unobjected to during the testimony, so now in closing argument, the state attorney is, in rebuttal closing, is commenting on the evidence that went into before the jury unobjected to. Isn't that okay?
it's a separate error when it's actually elicited during closing argument as well. So during testimony is one error that could be objected to, and during
But it
closing
wasn't
argument-
objected to. I mean, I get it. If it was objected to and the judge sustained it and then talked about it, then you talk about it. I get that. But I mean, here, I thought it was kind of brought into evidence without objection, and now we're at closing. Does that make a difference in your mind?
No, it does not.
Why not?
Because if it's elicited during questioning and an objection is successfully sustained.
There was
No. You're missing the point that it was her lawyer that asked her that question. And as best, unless it's like a Mel Brooks saying, I don't think that her lawyer is going to ask her a question, then immediately object to his own question. The question, was, or during direct testimony, Gutierrez stated that she told Cartagena that the drugs were not hers. And then she said, but he wasn't really trying to hear it, he just, like accusative, So that is elicited by her lawyer on direct examination. So there can't be an objection to it because he's eliciting it. Once he elicits that, isn't it fair comment for the state to say, well, you told the police officer this, but you didn't tell the police officer that?
I believe where we may be missing each other is she did state that I did say these weren't my drugs, and it was the officer who had testified that she didn't tell me anything. And that actually was objected to.
Would it have made a difference if they had asked her that? So she says, I told him that the drugs were not hers. And then on cross-examination, could the state have elicited, but you told him this, but you didn't tell him that you were going to throw the drugs away?
And that is our argument, is that it's a failure to make an exculpatory comment while she is at the very least detained, and that the state cannot reference.
Right, so you're suggesting that after she testifies, if that had been asked on cross-examination, that would have been improper as well?
Yes, unless it's inconsistent with something she had previously said before.
Well, why isn't that inconsistent? Why isn't it inconsistent where she said, where she says one thing but doesn't say something else? That's not inconsistent?
No, because then we're going back to the failure to make an exculpatory comment. If I'm understanding your question correctly.
I think you get it. I think,
I'm just, it looks like on transcript page 200, in cross-examination, she was asked, you didn't say you wanted, to the officer, you didn't say you wanted to throw it away, right? Correct. And during that time, you didn't say that you wanted to turn it into law enforcement, right? Correct. Gutierrez does not object. I mean, so I get what your argument is if this comes out of the blue in closing, but I mean, I get what you're saying. I don't know if I necessarily wholeheartedly agree, but I get it. Here, she's asked these questions. Your trial counsel doesn't object to that. So it's in evidence, and the jury has heard this evidence. So now in closing, the prosecutor's arguing what the jury heard to unobjectedly, and you're saying this is reversible. Am I understanding your argument?
Yes,
Okay.
yes.
All right.
And I believe in the case law cited in the brief,
I don't know. It's ice novel.
and I believe there are some cases in the case law cited in my brief where it was the closing that was objected to, the prosecutor making arguments like, you would immediately tell someone if you were innocent, things to that effect. And that was objected to as opposed to the questions. So that's why I'm making the distinction between objecting during the questioning and objecting during the closing.
You're into your rebuttal, which is my fault. So Why don't you reserve the rest, and if necessary, I'll give you a little extra time,
Okay,
okay?
thank you.
All right.
Good morning.
Good morning.
May it please the court, my name is Deborah Chance on behalf of the state. Your Honors, the state would submit that the trial court properly declined to instruct the jury on the defense of temporary possession for the purpose of legal disposal. And the state would further submit that the state's closing argument was not an improper comment on the right to remain silent. It appears Your Honors are very well versed with the arguments in my brief. If you don't have any questions.
If the questions were never asked on cross by the prosecutor about, you didn't tell the officer you didn't want to throw it away, you wanted to throw it away, you didn't tell the officer you wanted to turn it into him, if those were never asked, and then just on closing, rebuttal closing, which historically as a trial judge seemed to be the biggest problem I used to have with prosecutors, but that being said, I digress, would you have more of a difficult position here would that be a comment on the right to remain silent that was based on no evidence that was heard by the jury leading to that point?
Well, as you said, this was in rebuttal. This was in the rebuttal portion of the state's closing argument. In defense counsel's closing argument, the entire theme was that the detective had basically failed the defendant. He conducted it wasn't a thorough investigation. He was simply placing the blame on the first person he could find. And the suggestion was, had he merely asked her more questions, more detailed questions, asked the right questions, she would have been able to proffer an explanation that was reasonable and would have explained why she possessed the drugs.
So the officer should have said, okay, ma'am, did you plan on turning these things over to me?
No, I don't think so. But what I'm saying is that if defense counsel is arguing that in closing, the state was, it was more than proper for the state to comment upon the defense that was presented and respond to it. And that's merely all that they were doing. They were simply pointing out that it was unreasonable, it wasn't plausible, this defense was not a reasonable.
Once a defendant makes statements, whether it's on questioning by law enforcement or by testimony at trial, is it your position that at that point, what wasn't said isn't a comment on the right to remain silent because the person has not exercised their right to remain silent?
Are you saying post-arrest or post?
I'm saying either post-arrest in statements to law enforcement, or if they, well, let's start with post-arrest. They make statements to the law enforcement.
I would agree that there's certainly cases holding that, pointing out that there was no exculpatory explanation given, they never said anything. There are cases saying that. However, what we have here is her own testimony at trial that she didn't have a chance to talk. She tried to explain, but he cut her off.
What if she had exercised her right to remain silent with the law enforcement and she gets on the stand and testifies? You certainly then can't ask her why you didn't say that to the police officer, can you?
Right. In this case, that's not what happened, though. I agree with you, but that's not what happened in this case. In this case, she stated on the stand, she tried to explain to him, he cut her off, he wasn't really trying to hear it. She tried to explain they weren't her drugs. She stated she was nervous. And the state was merely pointing out that, she claims that she didn't have a chance to talk, but she stated she was nervous. She claimed she didn't have a chance to talk, but the facts indicate that she then provided contact information for her male companion's mother. They tried to contact her, apparently. She stated that, according to the police officer, it was cocaine, that she was nervous. The state was merely pointing out that her explanation that she didn't have the chance to provide an explanation was not reasonable based on her testimony. And this was in the rebuttal portion of closing argument, as I stated. It was a fair comment based on all the facts and circumstances of this case.
Any further questions?
No.
All right, thank you.
All right, thank you. I'd ask that you affirm.
If she didn't say that, I would have been unclear.
Yeah. She got that in under the wire.
And just to briefly rebut on the infringement of the right to remain silent. So Regarding this being a fair comment on arguments that were made during the closing argument, since this was made during the state's rebuttal portion, as I previously iterated to the court, the statements made by the appellant were still made when she was under detention or arrest. Just her saying that she's nervous is not inconsistent with the statements that she did give to the officer regarding the information of Star or Estrellita.
The one case you rely on is the Monroe case, right? Isn't that the case that you're really citing?
Yes.
Okay. But in that case, the defendant never spoke to law enforcement. That was the second example that I just asked the state about, where the defendant effectively exercises their right to remain silent and then gets on the stand and testifies. And that seems to be the classic case of commenting upon the defendant's right to remain silent. But isn't it distinguishable because in this case, your client did talk to law enforcement?
And our contention is no, it's not distinguishable, because although she did at first speak to the officer, her failures to make exculpatory statements, her failure to say this, this, and this is still protected, because at that point she wasn't given.
What case do you cite for that proposition, other than Monroe?
So the case law that I cite for that proposition, I apologize if I may just have a brief
No,
moment.
that's right. I said I'd give you some extra time if you needed it.
So we do have Chamberlain v. State cited in the initial brief.
And what were the facts of that case?
There, the defendant never made his exculpatory comment until trial, which was,
All right, but again, what I'm looking for is your best case where the defendant makes statements to law enforcement and then is asked about those on cross-examination, or the comment is on closing arguments.
well, unfortunately, I just don't have anything available offhand,
All right, fair enough.
admittedly to the court. But nevertheless, our argument is that the state could not rely on her failure to make an exculpatory comment when she was in a situation where she should have been Mirandized, and this goes to the crux of the right to protect oneself against self-incrimination. When someone is in that position where they haven't been Mirandized, where they're in custody, how can one be expected to make exculpatory comments and have that failure be used against them at trial?
All right. All right, thank you, sir.
Thank you.
Now, you're with Mr. Wesley's office in Orlando, is that right?
Yes.
All right. I could say that I think that when folks from your office have come up here, as you have done today, that you all do an excellent job in terms of your briefs, your brief writing, as well as your oral presentations. It's always a really enjoyable experience when folks from the trial lawyer's office come up here and do an appeal. So it was nice to meet you and nice to have you up here.
Yeah, thank you. Thank you for allowing me to be up here.